Welcome everybody. My name is Jeff Fowler, President of the Apartment Owners Association. Rent control in Buena Park? There's no rent control in Buena Park. Well, actually there is, and it's in the form of tenant protections, and we're going to cover that today. And before we get started, just a little bit about AOA. We're the largest individually organized group of apartment owners here in the state of California, and man, we've been so blessed through the years. Been around for over 40 years. My dad founded it. Here I am, stepping in his shoes now, and it's been quite a journey, and just so blessed, so blessed, so thankful. And really, the goal of the company from the very inception is to help you make more money, keep more money, manage your properties in a way that's easier than ever before. That's really what we want for you. Our goal is that this group of apartment owners would be the most successful in the entire state, and so we just want to keep everybody informed. And if you are not a member, what you don't know may cost you a fortune. Definitely join AOA if you're not a member. It's $97 for an entire year. That's there's no per unit fees, and there is a 100% money back guarantee on it. If for any reason that you're not satisfied with it and it's your first year, we'll give you your money back. So there's no risk. Earlier this morning, we had a live stream already, and it was about ADUs, and so you can catch that on YouTube. Just search AOA USA, and you'll actually see that there's a whole library of videos. And Thursday at 10 a.m. there'll be another live stream about Delaware Statutory Trust, and just how you can save big if you're maybe in your fourth quarter and thinking of exiting, or just wanting to exit California and go into something different. And tomorrow in San Diego, we have a political action roundtable, property rights roundtable in San Diego, so check our seminar schedule for that. Oakland on the 19th, we have a How You Can Avoid Procedural Mistakes in Eviction Actions seminar, so check that one out. Santa Clara on the 26th, we have a in-person seminar, and that's about maintenance of your rental units, and then also landlord rights, your rights to inspect that unit. And then, of course, we have the trade show. That's coming up on October 19th. We're going to have over 20 speakers. There's going to be over 150 booths, and it's going to be an incredible time to be together and sharpen the axe and stay agile. And anyway, so I hope that you're able to go to that. If you go to aoausa.com, you'll find out more information about who those speakers are at the trade show, and you will be able to register for that. So I want to invite you to do that. You don't have to be a member to do it, and actually, if you're not a member and never been a member, if you go to that show, you'll actually get a 6-month free AOA membership, and no strings attached to that. And if you are watching this video on aoausa.com, there is a blue little bubble at the bottom right side of the screen. You can enter questions there, and they will get those questions to me after our speaker is done presenting. And anyway, so we're going to get to it now. Our speaker today has 25 years in the industry, 16 specifically as an attorney. He's the president and founder of Brennan law firm, and it's not just an eviction firm, it is landlord tenant law and evictions that they do. And so our speaker today, he's definitely a favorite at the trade show that we do, and that will be Long Beach. I think I mentioned that, but he'll be there 9 a.m. Don't miss him. Please don't miss him. You won't want to, because he is a wealth of information, a tremendous resource for apartment owners. He writes articles. He's on so many different boards, and just helps our industry in so many different ways. So it's really a pleasure to introduce to you today Michael Brennan.
Thank you, Jeff. I appreciate all of that. And I do a very quick little bit of intro on top of what Jeff said. I am Mike Brennan. I do own Brennan Law Firm. We are a landlord-tenant law firm. We represent landlords exclusively, and our main office is in San Gabriel Valley here in Southern California. We do handle landlord-tenant law all the way up to Kern County and down to San Diego County. So We are in the courts every single day throughout Southern California, and we really utilize that to stay on top of the changing events and what's happening with the courts, what's happening in the legal system. As Jeff mentioned, I do sit on, I've sat on multiple boards of directors throughout the years, and I'm deeply involved in the legislative end of things, deeply involved, invested into the industry. And as a result of that, I often see a lot of laws that are coming out before they actually come out. And we get to take place in trying to craft those laws so that they have either a positive impact or as little negative impact as we can. Oftentimes very difficult, very challenging situation. Having said that, today we're here to talk about rent control. We use that as an umbrella term, rent control in Buena Park. And I'm going to give you some disclaimer language right off the bat. Nothing in here is legal advice. If you have a property in Buena Park or you're thinking about buying a property in Buena Park, I would encourage you to speak to an attorney that understands the area, understands the interplay between the state laws and Buena Park's municipal code down there, so that you know what you're getting into. Everything I talk about today is going to be general in nature, but it is going to go through the specifics of Buena Park's what we would call a just cause or a tenant protection ordinance. So the purpose of the webinar today is to explain Buena Park's tenant protection ordinance that was recently passed, maybe within a couple months ago. The ordinance itself is commonly called just cause, and it's important to distinguish that from rent control. So we'll go through that, and I'm going to give you some definitions in a second. But after we're done going through the just cause ordinance, then hopefully you'll walk away with some guidance on what the requirements are, what properties it covers, does it cover your property, what are the exemptions, what are the notice requirements, everything to help you navigate that new code effectively and efficiently without running afoul of it. So before we get too deep into everything, let's start with a few definitions. As I said, it's only been the last few years where a lot of tenant protection ordinances have been passed by cities. And people often confuse the phrase rent control with tenant protections, and they're really not the same thing. The first definition I'll start off with is tenant protections. Tenant protections, I would say, is an umbrella term that can mean either rent control or just cause ordinances or a combination of both. Some cities are enacting anti-tenant harassment ordinances as well, and that could fall under the umbrella phrase tenant protections as well. So when you hear me say tenant protections, it could mean rent control, just cause evictions, anti-tenant harassment. There's a lot of things that fall under that phrase. When I use the word rent control, that's a very specific type of law. It's as the name implies, and many people already know this, it's a regulation on the amount of rents a landlord can charge or increase when you have an existing tenancy. Buena Park itself does not have its own rent control ordinance. The City Council considered it over the last year, and it looked like the City Council was going to pass it. They unanimously stated that they see the need for rent stabilization. But after efforts of a lot of organizations in the industry, the fact is, at the last second, they voted against it, and instead of implementing rent control, they left it alone, and they voted in a tenant protection ordinance called Just Cause. Now, that doesn't mean that Buena Park does not have rent control. Buena Park does, in fact, have rent control, but it is not Buena Park's law. Buena Park falls under the state law called the Tenant Protection Act, or the TPA. And that applies to virtually every residential rental property in the state of California. So every city technically can have rent control. But Buena Park itself does not have its own ordinance or law that governs the rents over landlords. So one of the things you'll see as we go through this is this ordinance, this Just Cause ordinance, looks very similar. If you're already familiar with the Tenant Protection Act or the TPA, it looks very similar to that. It does have some nuances and some different requirements and different language and different amounts of relocation fees, but it is structured very similarly to the Tenant Protection Act. And so while the Tenant Protection Act, if you think about that phrase I just talked about, tenant protections, and then the Tenant Protection Act, it has both rent control statewide. California, the Tenant Protection Act is a statewide law. It has both rent control and Just Cause. And so Buena Park falls under that. But Buena Park does not have rent control per se. They do have Just Cause. So let's talk about Just Cause. And just cause, or what we would call JCOs, is a relatively new phrase that landlords are starting to hear and understand and see in courts and things of that nature. And you can have a city like Buena Park that has just a just cause ordinance, which, like I said, they just recently passed that. So just cause ordinances are laws that prevent landlords from terminating a tenancy for no reason. In other words, in order to terminate a tenancy, there's got to be a just cause or a valid reason. Typically, there's going to be two different categories that'll fall under a just cause ordinance. You'll have a no-fault category, and you'll have an at-fault category. And this is true of virtually every type of tenant protection just cause ordinance out there. You have no faults and at-faults. The no-faults there's relatively few of them, maybe a handful, depending on which ordinance you're looking at. Buena Park, I think they have 4 or 5. We'll go through them. And then the at-faults, there's a significant number of at-faults. So we'll cover all of those today, and we'll go through them one by one and let you guys know exactly what they are and how they work. In addition to implementing the just cause requirement in order to terminate the tenancy, most just cause ordinances also come with additional administrative requirements that landlords are required to follow in order to be in compliance with the just cause ordinance. So for example, the city of Buena Park has very specific language that needs to be in some of the notices. And like most just cause ordinances and rent control ordinances for that matter, if you are not in compliance with the administrative component of the ordinance, then any sort of an eviction you attempt to file will be invalidated, or the tenant can raise it as an affirmative defense that you're not in compliance with the administrative component, and it could cause you to lose your case. So we'll talk about those administrative requirements today as well, what notices are required, what language is required. Again, it differs a little bit from the Tenant Protection Act. All right, so we're going to walk through Buena Park's just cause ordinance. We're going to go through the permissible reasons to terminate a tenancy as well as the additional administrative requirements. And then we'll wrap it up with some relocation fees and some thoughts off the top of my head about where we're going with all that. So having said all that, let's just jump in. The first question you want to ask yourself is, where can I download the ordinance? And a lot of landlords are not used to reading the ordinance. And I encourage you, no matter what city you own a rental property in, if it's got either a just cause or a rent control or any sort of tenant protection ordinance, I would encourage you to figure out what the code number is, download it and read it 3 or 4 times. Just in preparation for this webinar, and I do this for a living, every day of my life, I read that ordinance probably 4 times, highlighted it, then went back with a red pen, circled it, had to think about it. What does that mean? So the reason I'm encouraging landlords to do that is because while some of them can be very complicated, some of them are fairly easy. Buena Parks, I would say, is one of the easier ones to understand. But it's important that you understand what you are dealing with and how you have to deal with it. And simply, while a webinar is great to give you a primer on it, I think if you're the owner of a property in that city, Buena Park, then you should download it. So you can Google Buena Park Municipal Code, section 8.60. And what you'll want to review are the sections 8.60.010 through 8.60.090. That's the entire code, and it sounds like a lot. It's really not that much. But like I said, I encourage you to download that and read it very, very thoroughly. If you have questions, you can certainly call AOA. They can help you walk through it, or you can call my office, and my staff is pretty well informed about this ordinance. They can help you walk through it as well. As I said earlier, if you're already familiar with the Tenant Protection Act, Buena Park's ordinance is going to seem very familiar to you, and you can navigate it fairly easily. So that's the first question. Where can you get the ordinance? Where can you look it up? What's the code section? The next question is going to be, which rental units does the just cause ordinance apply to? Or another way to phrase that is, does it apply to my unit? And to answer that, the short answer is yes, it does. It applies to all properties in Buena Park, and we'll go through some exemptions. But here's another distinction between rent control and just cause that's really important to understand. Rent control is governed by another law called Costa-Hawkins. And Costa-Hawkins was passed in the early 90s, and it protected landlords, and it has restrictions on what the cities can implement and what they can regulate in relation to setting the initial rent or increasing the rent for an existing tenancy. Just cause ordinances have no similar law. There really is no, Costa-Hawkins does not apply to a just cause ordinance. And so there really are almost no limitations on what a city can implement as far as their just cause ordinances. And there's case law out in the world that says a city can limit what a landlord can evict for, but they're not allowed to expand it. And so that's an important rule to understand. Some ordinances, for example, the City of LA, will list reasons that you can terminate a tenancy, but if you were to try to do that, the courts would rule, well, that's not a recognized reason. Even though the city says you can do that, you're limited by what the state says. In other words, the city is trying to expand the reasons, believe it or not. They're trying to expand the reasons, and so some of those are unenforceable. On the other hand, the city is permitted to limit the reasons that you can terminate a tenancy. And with just cause ordinances, what's important to remember is what the cities are attempting to accomplish by passing these is they're attempting to protect the tenants from simple, arbitrary terminations of their tenancy. They don't want people out on the street for no reason. And you know, let's say 10 years ago when we had significantly fewer rent control or just cause ordinances, there were a lot of evictions done on a simple 30-day or a 60-day notice for no reason whatsoever. And there are still some properties that you can do that on. For example, if you had a property in Buena Park that was, or not, that was a bad example. If you had a property over in Anaheim and that property was less than 15 years old, you wouldn't have to have a reason to terminate a tenancy. But as soon as a just cause ordinance is passed, now all of a sudden you need these reasons. You can't just terminate it for no reason at all. So again, which rental units does Buena Park's just cause ordinance apply to? It applies to all of them. I'll give you a distinction between Buena Park's and the City of Los Angeles. The City of Los Angeles Rent Stabilization Ordinance states that that ordinance applies to properties with 2 or more rental units on it. So the RSO, as we would call it, LARSO, would not apply to a single family house. That's not the case in Buena Park. Buena Park's applies to all rental properties out there. Now, the question becomes, when does it apply? And that's a different story. So Buena Park's does not apply from day one of the tenancy. Important note. It only applies after the tenant has been in possession, what they call lawful possession of the property, for 12 months. That's when it kicks in. There's an exception to that. If a new occupant is listed as a lessee, it could extend it to up to 24 months. But essentially, those first 12 months, Buena Park's just cause ordinance does not apply. So just as a strategic point of view right now, if you are concerned about not being able to evict a tenant, owners of properties in Buena Park might consider moving to 9-month leases. At the end of that 9-month period, you're going to know whether that's a good tenant, whether it's a good fit. And if it's not a good tenant and it's not a good fit, you could terminate that tenancy on a 30-day notice without having to comply with this just cause ordinance. But once the tenant's there for 12 months, then this ordinance kicks in. Like I said, there's an exception, but I'm not going to get into the details of that exception right now. So it includes all rental agreements, all leases, and it includes tenants and subtenants. So think about that for a second. That could get a little bit complicated, right? You have a tenant, you have a lease with a tenant, and that tenant has gone ahead and sublet. Now, under state law, if the landlord did not approve that, that would be the basis for a termination. And that would be a basis for a termination under Buena Park's law as well. We'll get into that in a little bit more detail in a little bit. But the point is, it applies to all residential rental properties. It applies to all rental agreements, leases, tenants, and subtenants. In other words, it wraps everything up with the exception of some exempted categories that I'll talk about in a second. Like I said, it might make sense, if you're concerned about this, to move to a 9-month lease so you can make a decision at the end of 9 months. Do I like this tenant? Do I want to keep them here? Or do I just want to terminate them without the hassle of having to, document some legitimate reason for it? So think about that. All right. So the next question would be, what are the exempt units? And there's a whole list of them. I'll give them to you, not in the order they appear in the ordinance itself, but I'll give them to you in the order of importance as far as my position is concerned. I just mentioned the first category, the tenancy hasn't yet matured yet. So if you have a tenancy that's less than 12 months, the ordinance doesn't apply yet. That is an exempt category. That's your first exempt category. Your second would be, well, I guess this is a little bit out of order, I apologize. I thought I changed this, but it appears I didn't. Anyway, so it is in the order that they're given in the ordinance. The second is going to be transient and tourist hotels, and that's defined in Civil Code Section 1940.b. If you're wondering what that means, I'm doing Airbnb. Does that apply to me? Look up Civil Code Section 1940, subsection B, and if your property falls into that definition, Buena Park's ordinance would not apply to you. Third category is lodgers, and this would be where a tenant shares either the bathroom or the kitchen facilities in, let's say, a single-family home with the owner who occupies the property as well. Exempt, you don't have to worry about it. And then single-family owner-occupied residences where the landlord lives in the single-family home and rents out no more than 2 other, let's call them bedrooms or an ADU or a combination. Let's say you live in the single-family home and you have an ADU and you rent out 1 bedroom inside the house and 1 ADU, you're still exempt. But if you were to rent out 2 bedrooms in the house and the ADU or a junior ADU, you are now no longer exempt. And so that single-family home with up to 2 rentals inside of it or an ADU, that's also exempt. Duplexes are also exempt, provided 2 things take place. 1, the owner occupied one of the units at the duplex at the time the tenancy was created, and 2, the owner maintains that as their primary residence. In that situation, the duplex would be exempt. So many of you are, as I said earlier, are listening to this saying, this sounds just like the Tenant Protection Act, and it is very similar to the Tenant Protection Act. And I think that might be why Buena Park left rent control out of the picture, is because the Tenant Protection Act is already there. It already is governing rent control in Buena Park. And so you can see how they worked to fold this just cause ordinance in with the Tenant Protection Act. But we are going to talk about some nuances of Buena Park's ordinance that make it a little bit more stringent than the Tenant Protection Act when it comes to just cause. All right, the next exemption would be any sort of housing, residential rental housing, that was issued a certificate of occupancy in the last 15 years. Again, that's exactly out of the Tenant Protection Act. If you have residential rental property issued a certificate of occupancy in the last 15 years, your property is not controlled by the Buena Park Just Cause Ordinance, nor is it controlled by the Tenant Protection Act. So in that sense, it would be exempt from both just cause and rent control. All right, and then what I think is very important for a lot of the rental properties in Buena Park is property that's alienable, separate from the title to any other dwelling unit. So what we're talking about here is a single-family home, maybe a condo. It's got its own APN number. It's a single-family home that's got nothing else on the lot. But there are some provisions, some requirements for that exemption. The first is the owner can be neither a REIT nor a corporation nor an LLC that has a corporation as one of its members. And then the second requirement for that exemption is where it gets a little strange, or convoluted, I should say. In order for that exemption to apply to your rental property, like I said, you can't be a REIT, a corporation, or an LLC with a corp as a member, and you have to have given the tenant the notice that the property is in fact exempt from Buena Park's rent control, just cause ordinance. Now they have some dates in there and it gets a little strange. Buena Park's ordinance, I don't mean to knock those who drafted it, but it's not a model of clarity, and here's where it gets a little strange. That notice that the tenant is required to have received, right in the ordinance, this ordinance was passed in 2023, but in the ordinance it states that for tenancies in existence prior to July 1st, 2020, the language does not have to be in the rental agreement. Why would it be? The ordinance didn't exist. So it can be done using a 30-day change in terms of tenancy. So if you've got that tenancy that existed prior to July 1st, 2020, serve a 30-day change in terms of tenancy. I'm talking about a single-family home, separately alienable from other property, falls under the exemption. The notice requirement could be done for that type of tenancy through a 30-day change in terms of tenancy. But then it has another provision. It says, for tenancies created or renewed after July 1st, 2020, it has to be in the rental agreement. If you don't already have it in the rental agreement, which again, why would it be? This ordinance didn't exist and the Tenant Protection Act was just coming into existence, then you would have to do that as an addendum. And the difficulty with the addendum is that an addendum has to be signed by all parties to the contract. So it's not just the landlord doing a 30-day change in terms of tenancy, it's the landlord serving an addendum and getting the tenants to sign the addendum, making that part of the rental agreement. And if you've ever had to struggle with getting a tenant to sign something that limits their rights like that, you can imagine if I walked up to you, a tenant right now, and said, hey, I want you to sign this addendum that allows me to terminate your tenancy because I'm exempt from this Buena Park just cause ordinance, the tenant might be hesitant to sign that. So it's like I said, this is not a model of clarity, and it's a little strange with these Tenant Protection Act dates in it. But I think that was because they were drafting in haste and trying to get it passed. And so I anticipate that they'll clean this up or clarify some of this language down the line. There's a third date in there that does make sense. This one, for the same exemption, single-family home, separately alienable, or condo, separately alienable. It says, for tenancies created after August 1st, 2023, that notice requirement is completely different language than the other two requirements I just talked to you about. The other two requirements take the language almost verbatim right out of the Tenant Protection Act. This language actually, for a tenancy that's created or renewed after August 1st, 2023, the notice language specifically mentions the Buena Park just cause ordinance and says this property is exempt from Buena Park's just cause ordinance, etc. So that one makes a lot more sense. Again, for new leases moving forward, if you don't have that in your lease, your single family home will not be exempt and it will be subject to the Buena Park just cause ordinance. So if you need that language, like I said, I gave you the code section, you could look up that code section and look up that section of the code and find the very specific language you need to put in your leases. You could just add it to your new leases coming up. Now, for leases that renew, let's say you have a tenant that, I don't know, they moved in, let's say, in April, and next April their lease is going to come up. You could still add that. You could have them sign a new lease, and we'll talk about this in greater detail in a few minutes. You could have them sign a new lease or renew, and you could add that language, and the ordinance says that would be perfectly fine. That's not a term that's so significantly different that they wouldn't have to sign it. So there is a way to work around this stuff, but if you want that exemption, that single-family home or separately alienable exemption, you will have to have the notice language in the lease. All right, the next category of exempt properties are affordable housing for persons and families of very low, or moderate income that are restricted by deed, regulatory restriction in an agreement with a government agency, or some sort of other recorded document. So what are we talking about here? Think about tax credits. There are properties out there that have a deal with the city government, and if they keep them low to moderate income or very low income, they can record this document that will give the landlord tremendous tax benefits. Those cases or those properties rather, are also exempt from this just cause ordinance. And the next category probably doesn't apply to too many people on this webinar, is nonprofit hospitals, religious facilities, and care facilities. So ironically, right now I do have a case with a client where we are terminating a tenancy and it's owned by the Catholic Church. And so that is not governed by this, and it's not governed by the Tenant Protection Act because it's owned by a religious facility. So it does happen. And then the last category of exemption is dormitories at higher learning institutions or kindergarten through 12th grade, like a boarding school. Those would not be covered as well. So those are your exempt categories. We'll move now into what are the two different categories for just cause. So you have the at faults, which we'll talk about first, and then we'll move into the no faults. So we'll start the at faults with unpaid rent. Unpaid rent is always going to be a material breach of the lease. And under this, if I'm interpreting this ordinance correctly, and I think I am, but there is some convoluted language in the ordinance that casts a little bit of a doubt. But if I'm interpreting this correctly, unpaid rent you can still terminate a tenancy based on a very simple 3-day pay or quit notice. But that's not true for other breaches of the lease. So much like the Tenant Protection Act, the Buena Park Just Cause Ordinance states that if you have some other material breach of the lease, then you first have to serve a warning notice, which would be a 3-day warning. It doesn't specifically state the number of days. It says you have to give a notice and an opportunity to cure. My office has always taken the position that, well, 3 days, since the state allows a 3-day cure, covenant, or quit, that's a reasonable time frame, so we use a 3-day warning. And if the tenant fails to cure that violation within that 3-day time period, when it expires, then you are now required to serve a 3-day quit. They no longer have an opportunity to cure, but you still have to serve what amounts to a 7 or 8 day notice. Since weekends and holidays can't count, by the time you get done serving the first 3-day warning and then the 3-day quit, there's going to be a weekend in there. In most cases, you're looking at a 7 to 8 day notice at this point. So 3-day pay or quit for non-payment of rent, material breach of the lease, you're looking at a 7 to 8 day notice, 2 stages, warning first, and then the 3-day quit. I want to make sure I didn't miss anything here. All right, like I said, so is non-payment of rent a material breach of the lease? Sure it is. Every court recognizes that. Like I said, there is some language when the ordinance is talking about the requirement to serve the warning notice first. That provision of the ordinance specifically states for curable breaches, the owner has to serve this warning notice first. Well, a non-payment of rent is a curable breach. The only reason I can confidently take the position that you can still serve a 3-day pay or quit on a non-payment of rent is because down further in the language, it does state in conformance with Civil Code Section 1161, subsection 3, which is a breach of the lease other than non-payment of rent. But the ordinance itself is not clear on that at all. So I suspect that's one thing that the City Council will be clearing up. For right now, I feel confident telling you you could do a 3-day pay or quit for a non-payment of rent, but you have to do the 2 stages, the warning, then a 3-day quit for any other violation of the lease. All right. The next category, so we've got unpaid rent, breach of a material lease term. The next category, as usual, you find this in all tenant protection ordinances, nuisance. So what is a nuisance? The first thing I'll tell you is that nuisance cases have gone up about 600% to 700% in the last decade. I think people are just going crazy. Nuisance is a very broad category and has no less than 3 different definitions in the codes: the Civil Code, the Code of Civil Procedure, and the Civil Code that deals with evictions. So nuisance, broadly defined, is anything that's offensive to the senses. So you could have a nuisance because somebody is, let's say, cooking fish and that odor is wafting into the neighbor's unit. Or you could have a nuisance where a tenant is smoking marijuana and that smoke is drifting into the next door neighbor's unit. And I make this joke, but it's not really a joke. Invariably, every time we deal with that situation, the next door neighbor has a kid or more than one kid that has asthma, and you've got the one tenant who's smoking marijuana in their unit. So, and it's just irritating the asthma of the child next door. That is also a nuisance. What we see more often than not right now as a nuisance is threatening behavior, threatening the landlord or a manager, actually physically assaulting a manager. You can have a nuisance where you have a tenant driving drunk on the property and they take out a pillar on the property. That's a nuisance. There's a lot of different behaviors that can fall under this nuisance category. And luckily, that is one of the permitted reasons to terminate a tenancy. The next category is a refusal to execute a written extension or renewal for a similar term with similar provisions after a written demand by the landlord. So let me walk through that. Let's say you have a new tenant. They moved in last April, they're on a written lease, and their lease expires March 31st, 2024. If you send them a new lease, which hopefully you will, that's got the required language in it that you now need, you send them a new lease and with a letter that says, hey, please sign this new lease, with the exception of the additional language allowed by the Buena Park Just Cause Ordinance. It's virtually the same lease. Please sign this and return it to me. And the tenant refuses to sign that and return it. That would be the basis for terminating that tenancy. or you're simply trying to renew it instead of implementing a brand new lease, that too would be the basis of a termination of a tenancy. As long as the landlord puts it in writing that they want the tenant to renew or sign the new lease, and the tenant refuses, you could terminate the tenancy based on that. And I just want to make sure I'm not missing anything on that. All right, and then we have another category, sounds very similar to sounds very similar to nuisance. That's called criminal activity. That criminal activity has to happen on the property, including the common area, or this is an expansion of a tenant it's an expansion of a landlord protection actually, but it's either on the property, including the common areas, or any criminal activity or threat under Penal Code Section 422A on or off the property directed at the owner or the owner's agent here. So what are we talking about here? Any sort of threat of physical harm, that's 422A. Threatening your manager, threatening the owner. It doesn't have to occur on the property. It could occur through an email. It could occur through a letter. It could occur face-to-face at the supermarket. Any sort of threat, physical harm to the owner or the manager is grounds for terminating the tenancy. That category gets expanded to any sort of criminal activity on the property. Now, I will point out that one of the nice things about Buena Park and the Tenant Protection Act is that they leave some language out that I'm starting to see in other tenant protection ordinances that are passed. Specifically, they do not require that the tenant be convicted of the criminal activity, and I am starting to see that pop up. It just says criminal activity. So in other words, if somebody's arrested on your property and there's police involved, they give you their card, they give you an incident number, that's criminal activity. If there's a raid on the property for, let's say, narcotics, or somebody is not complying with their parole and they raid it and they arrest people, that's all criminal activity. Like I said, other ordinances I'm seeing are starting to attempt to push through language that says the tenant actually has to be convicted of that criminal activity before you can terminate the tenancy based on that. And the problem with that, obviously, is most of these criminal activities never get prosecuted to a point where the tenant's actually, or the individual is actually convicted. They either plea bargain out or they get dismissed in that in the initial stages. And the problem for you as a landlord, if you were in that jurisdiction that requires it, is that you've still got that individual on your property who happened to plea out of the conviction, and now you're still dealing with it. So again, Buena Park allows you to terminate the tenancy for criminal activity, and you don't need to actually have a conviction. All right, the next category is assignment or subletting in violation of the lease term. Well, based on that language alone, what does that imply? You've got to have that language in the lease. Of course, AOA's got that in the lease, so that's really a non-issue. But that is also a basis for terminating the tenancy under regulars California Civil Code. It's also a basis for terminating a tenancy under the Tenant Protection Act. Again, I am starting to see other jurisdictions that, for example, Pasadena has Measure Age. That they're not so quick to allow you. There are requirements that need to be met before you can terminate a tenancy for an assignment or a sublease. Their goal is to force the assignment or the sublease to remain to be permitted and allow it to remain in place. And Buena Park did not go in that direction, thankfully. All right, the next category is refusal to allow access to the property for. This is an interesting two categories. The first category, I'm not going to give you the code sections, you can read it in the code, but the first category is if they do not allow you to enter the property to install low flow water fixtures, like your toilets, that's the basis for a termination, or Civil Code Section 1954. What does that mean? All right, I'm going to go through them real quick because they're fewer than you might think. In case of an emergency, let's say there was a water leak or a gas leak and you don't know where it is and you're trying to figure it out and the tenant's not letting you in the unit. That would be the basis for a termination of a tenancy. To make agreed or necessary repairs, decorations, alterations, or improvements. If the tenant refuses to let you in. Now, notice I said decorations, repairs, alterations. You don't have to have a habitability issue that requires your attention to get in a unit. If you want to go in and measure it for new window coverings, you as the landlord are allowed to do that. And if the tenant is refusing to allow you access to get in to do those measurements or to provide any sort of service that is necessary or agreed to, that would be the basis for a termination of a tenancy. Now, Now, you cannot abuse that. Abuse would be any overuse of that in an attempt to get the tenant to vacate. But if it's a legitimate need to get in that unit and the tenant is denying access, that is grounds for termination. All right, the next category for refusal to allow access is under a court order. I'm not going to get into that. That gets complicated. And then another category is to conduct a balcony inspection, which is mandatory now. So if they're not letting you in to do that, that's another ground for terminating the tenancy. And last, but certainly not least, because it's very important, if you need to get in to conduct smoke detector or CO2 detector inspections and they're not allowing you in to do that as well, that too would be grounds for terminating the tenancy. All right, what about entry for other types of inspections? Let me give you a hypothetical. Let's say that the tenant is supposed to maintain some condition in the unit, or let me give you a more common example. Let's say you have a fourplex and you have one tenant that's complaining about roaches in their unit. And you get in there, you're exterminating, it's not getting rid of the problem, and you're looking at their unit saying that unit is very well maintained, the housekeeping looks good, the problem is obviously somewhere else. So you want to go in and you want to inspect the neighboring unit. Can you get in for that? The short answer is yes, because you have to look at it for, it might be a required service, right? An exterminator service. So you go in and you find out the next door neighbor is just a mess. Their unit's a mess, there's food all over the place, they don't seal things properly, they leave food out on the counter when they go. And so you give them a 3-day notice to cure that violation. Now, can you get in to see that they actually cured that violation? The answer is no. Under Civil Code Section 1954, that's not one of the permissible reasons. But what you could do is you could put that as a lease term, right? You will allow me access to inspect for violations and cure covenants, compliance with a cure covenant notice, etc. Now, if they don't let you in to do that, what is it to convert to? Well, it's not a failure to provide access anymore. Now it's a breach of covenant. Now they have 3 days to let you in, and if they don't, you're going to give them a 3-day quit. So this is very typical in all of these ordinances. They do limit the right of entry. They allow you to terminate a tenancy for the failure of the tenant to allow you in, but they do limit it to the Civil Code sections that I mentioned. But there is a way around that. And again, that just requires putting it as an extra provision or an addendum to your lease. All right, next category is using the premises for an unlawful purpose. Sounds very much like criminal activity, sounds like nuisance. What's the difference? So here we could be talking about an Airbnb, right? You've got zoning laws, you've got bed and breakfast zoning that permit Airbnbs, you also have zoning that prohibits Airbnb. So if the tenant is using it as an Airbnb, in addition to that violating your lease, that would be using the property for an unlawful purpose. You could have a tenant who is running, I literally have this case going on right now, a single family home in Palos Verdes, and the tenant has decided to run a car maintenance and detailing shop out of the property. Of course, that's a violation of the zoning laws, and so we are terminating the tenancy for using the property for an unlawful purpose, commercial endeavor that violates the zoning laws. All right, the next category, there's a few more categories. The next category is if you have an on-site manager, for example, and you terminate that employment and you want that property back, that unit back as a result of the termination. In that case, you would be able to terminate the tenancy based on the termination of the employment. All right, and this next category, I should say, because there's one more after that. This next category is very important. Not every ordinance has this. Again, going back to the city of LA, this is absent in the city of LA, but it's huge. Illegal holdovers. If you have an illegal holdover situation, you have the right to terminate that tenancy. So what do I mean by that? There's two situations right off the bat I can give you. The first would be you have a tenant that has terminated their own tenancy. They've given you a written notice, complies with the law, hey, I'm going to be out by March 31st, and then they fail to vacate. That's an illegal holdover. That is, you could terminate the tenancy based on that tenant's notice to you. Another situation that comes up, again, in the city of Los Angeles, I use that as a model a lot because it's got some real flaws in it. A voluntary vacate agreement. So let's say you enter into an agreement with the tenant, you're going to pay them cash for keys to vacate, the tenant takes your cash and then fails to vacate. And let's go one step further. Why would you use that situation? Well, we'll talk about relocation fees in a little bit. Maybe the tenant's willing to vacate for less than the relocation fees. Can you contract to do that? Absolutely. So the state can't tell you that you can't enter into a contract, nor can the city tell you that you can't enter into a contract with the tenant. So if you contract for some lower amount than the relocation fees would normally require, and you give the tenant the cash and then the tenant fails to vacate, now you have, again, an illegal holdover situation. So you could terminate the tenancy based on that. So that's like I said, that's huge to have that in there because it happens a lot. The tenant says, I'm going to vacate. They go out into the world and they find out, wow, I can't get another deal as good as I have here. I've changed my mind. I'm not leaving. And in the meantime, you've advertised the apartment. You maybe have somebody lined up to rent the apartment, and that tenant fails to vacate. So under Buena Park's Just Cause Ordinance, you can terminate the tenancy for that. All right. Last category, which I've technically never really seen go all the way to a judgment, is the category of waste. And that's a situation where you have a tenant who's, for example, building onto your, it's a little bit counterintuitive. It sounds like they might be destroying the property, but they're not. That would be nuisance or damage. This is a situation, let's say I've seen tenants in apartments that build on, or single family homes that build on an enclosed patio or something along that lines. That would be a waste situation. So those are the at-fault termination categories. Quite a few of them. They somewhat mirror the Tenant Protection Act. They're very close to the Tenant Protection Act, but they're not exact. So let's take a look now at the no fault. So that was at fault. Now let's look at no fault. No faults are a little bit different. Obviously, as the name implies, the tenant didn't do anything wrong. You're just terminating the tenancy. And there's really, I think it's 4 categories here that we're talking about. And again, they mirror the Tenant Protection Act with one exception that's important, and we'll get to that. It's the last one. But the first one would be owner or family member occupancy. In other words, the owner wants to move into the unit, or the owner wants to put either a child, a parent, a grandparent, a grandchild, or a spouse or domestic partner into the property. The ordinance in Buena Park allows you to terminate the tenancy for that purpose, but as you might have guessed, there's some conditions. So the first is, if your tenant agrees in writing to vacate based on that, then you have no problems at all. But the odds of that happening are pretty darn slim. And so the next provision or the requirement would be that there is a provision reserving that landlord's right to occupy the property in the lease. Now, it's only been since the Tenant Protection Act was passed in 2020 that we started including that language in the lease because it wasn't a requirement. When the Tenant Protection Act was passed and had that as a requirement, leases started evolving to include that language. So if you've got a tenant that's been in place since 2017, let's say, you probably don't have that language in your lease. And so you are going to have to either update the lease, have the tenant sign an addendum, or something along those lines. So without that magic language that reserves that right, you cannot use the owner occupancy exception, and you would not be able to do a no-fault eviction using that one. But if you've got the language, or you renew the lease and with a new one, or you do an addendum, then that would be one of the no-fault reasons. The next no-fault reason is an Ellis Act removal or a termination. Ellis Act, to make it really simple, is a law that was put on the books that said the landlord has an absolute right to go out of business. The only caveat I would tell you about with the Ellis Act is you can't just, if you have a 4-unit building, you can't just pick one unit and say, okay, I'm pulling that unit off the market. You would have to pull all 4 units off the market. But you have the right to do that. Now, if you have a single family home, and let's say you didn't have that language in there. Let's say you want your son or daughter to move into that property. You don't have the language. Well, wait a second. I can permanently remove it from the rental market under the Ellis Act and just let my son or daughter live there. Okay, that would be acceptable. So you've got there's 2 of the 4 no-fault evictions: owner occupancy, Ellis Act. The third one is an order to vacate issued by a court or a government agency. You're not going to see this by a court very often. It does happen, but it's very infrequent. But you will see this from a government agency. So where does this happen? Well, I would imagine that somebody listening to this webinar right now has purchased a building 4-plex or a 5-plex that was marketed as a 5-plex, and then they find out, well, wait a second, only 4 are legal. One's bootlegged, or one was a rec room that was turned into a unit with no permits or no certificate of occupancy. Happens all the time, and you can get a government agency who comes by and does an inspection and says, hey, guess what? There's no permit for this unit. That's illegal occupancy. You need to vacate that unit. So that would be a no-fault eviction. And by the way, all of these no-fault eviction require relocation fees, and we'll talk about those in a moment. And then the last category, and I think a very important category for investors, is the demolition substantial remodel category. And again, this is very similar to the Tenant Protection Act. A landlord there's 2 really important differences though. Landlord has a right under Tenant Protection Act and Buena Park's Just Cause Ordinance to terminate a tenancy if the landlord is going to demolish the property or do a substantial remodel on the unit. Now, where this differs from the Tenant Protection Act is the Tenant Protection Act has some requirements. Oh, you're going to do work that would require a permit, and you're going to do the work on the electrical system, the plumbing, or any of the systems in the unit. The difference between the Tenant Protection Act and Buena Park is Buena Park actually requires those permits to be pulled. And so we will go through these. So let's go through the requirements. You've got to be doing work that is going to replace or do a substantial modification to the structural, electrical, plumbing, or mechanical system of the property. Okay, you could change a toilet and you're doing something that affects the plumbing of the property. Is that a substantial modification? It's arguable. Would it require permits? Yes, so that could be considered substantial. All right, like I said though, it's got to require permits. Does it require a permit to change the toilet? It does, actually. In most cities, it does. And in this case, you would have to serve, along with the termination notice, you'd have to serve a copy of all of your permits with the notice. Now, where that'll get a little complicated is anybody who's ever done any sort of substantial remodel will know where I'm going with this. Sometimes getting all the permits that you need to do that remodel is not easy. And getting them all lined up and the timing for them is not easy. And getting the contractors to do the different facets of work all within relatively the same time frame is not easy. So the requirement that you pull all of the permits up front can pose a challenge, but I don't think it's one that's insurmountable. And again, that's different from the Tenant Protection Act. You don't have to pull permits under California's TPA. Buena Park, you do. All right. So any sort of replacement or substantial modification to the structural or the systems. The next one would be permissible under a substantial remodel or a demo would be abatement of hazardous materials. So you've got to show why this abatement can't be done in a reasonably safe manner with the tenant in place. And you've also got to show, and it's got to be in the notice, why does it require the tenant to vacate for at least 30 days? So if you're going to go down that path, what I would encourage you to do is any sort of a remediation company that's taking those hazardous materials out, have them put it right in the bid. Why can't it be done safely with the tenant in place? Why does it require at least 30 days to do it? And just for the record, what's included in hazardous materials? Well, they include lead-based paint removal, mold, and asbestos. And during COVID, we had several cases where a tenant had actually turned the landlord in for doing some work. It was all being done legally. But in the process of the work, the tenant suspected asbestos. And in a couple of the cases, there really was asbestos there. And so the tenant turned the landlord in. The landlord was fine because they had actually pulled the permits and done it correctly. But as a result of that ended up in an eviction on the tenant because the tenant at that point started fighting, but it's a permissible grounds for termination. So if you have to do asbestos work or mold work, and it's going to take more than 30 days and can't be done safely, you might as well go ahead and terminate the tenancy. Like I said, all the permits have to be obtained from all applicable government agencies first before you serve that notice, and copies of those permits have to be served with it. If the permit is coming from the city, just as a heads up, the city will require that you give them a list of all of the units that are going to be impacted and all of the units for which you will be terminating the tenancy. So there is that additional requirement, and again, that doesn't come up under the Tenant Protection Act. All right, let's talk about liability real quick. Again, a little bit of a distinction from the Tenant Protection Act. If a landlord attempts to use the substantial remodel as a basis for terminating tenancy, and it's discovered later that the landlord intentionally used that as a pretext just to terminate the tenancy, for example, they wanted to reset the rent. The Buena Park ordinance states that a landlord who intentionally violates that provision shall, which means strict liability, shall be liable to the tenant for up to $15,000. This is the key, plus reasonable costs and attorney's fees. Why did I say that's the key? Because $15,000, you may say, heck, it pencils out for me to do it if I can increase my rent up by this much. But the reasonable costs and attorney's fees, you now have a statutory reasonable attorney's fees provision that will circumvent any cap you might have in your lease. Most of your leases are capped at $500 or $1,000 in attorney's fees and costs, and you may mistakenly believe that protects you. But it doesn't, because the ordinance has an attorney's fees provision. So if you're going to do a substantial remodel and you're thinking about, or you're on the fence and you're saying, well, okay, maybe I can raise my rents to market rate by saying I'm going to do a substantial remodel, and it's found out later that you didn't really do it or it was a pretext, you could be on the hook for a lot of money, probably north of $50,000 to $60,000. So think about that. All right, we've discussed permissible terminations, we've discussed no fault, we've discussed ad fault. Let's take a look at the notice requirements now. There are several. I've kind of touched on a few of them. I talked about a non-payment of rent case. Again, standard 3-day pay or quit as far as I can see. Curable lease violations, you know, they're supposed to pay utilities, they're not paying utilities. You've got a no pets clause, they've got pets in there. You've got to give them that notice and opportunity to cure, and then you have to do the 3-day quit. No fault termination notice requirements, we've talked about that. All no fault termination notices have to include not only the basis of the termination, so in other words, if it's an owner occupancy, you have to say in there, pursuant to Buena Park Municipal Code 8.60 blah, 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 but I'm terminating your tenancy for owner occupancy. On top of that, the notice has to include the tenant's right to relocation assistance or a rent waiver. We'll talk about those amounts in a second. But so it's got to tell the tenant, hey, you have the right to either relocation assistance, I'm going to pay you X amount of dollars, or I'm going to waive X amount of dollars, and your last month's rent will be this month, and your last amount of rent will be this month. And the amount I'm waiving will be for this month. So it's got to have that in there. If it doesn't, your notice will be defective. These days, I really tell everybody now. In fact, my firm we're contemplating not taking cases anymore from clients who write their own notices. In this day and age, it doesn't make sense for landlords to attempt to do their own notices, even if you've read the ordinance. There's always, or oftentimes, some little nuance that most landlords will not understand, and when they do their own notices, they draft it incorrectly, and if they send it to us and we tell them, hey, your notice is drafted incorrectly, they get very frustrated, they have to redo it. Now that they've wasted time, whatever it might be, 30 or 60 days, they want to put somebody in there quickly, like their son or daughter, whatever the case may be. I just encourage you guys, for the money you spend to have a notice drafted by a law firm, hire a law firm to do it. Don't try to do these on your own and miss some little language that renders your notice defective. And I do want to give a very specific example of something. This is an evolving area of law right now. I'll give you a perfect example. In the past, up until maybe 2 or 3 months ago, notices were not required to say, like a 3-day pay or quit was not required. It said within 3 days you had to do this. And some tenants' rights law firms were attempting to have cases dismissed because in the code it says those 3 days can't include weekends, Saturdays, Sundays, or judicial holidays. But that language was not in the section of the code that said the notice must state. So in other words, you didn't have to say in your notice, not including Saturdays, Sundays, and judicial holidays. And we won that motion for years and years and years. And recently, a judge who ruled in our favor, it wasn't on my case, but that judge or commissioner really, would consistently rule in favor of us, of the landlord, on those cases. That commissioner was overturned in the appellate court just recently, within the last 2 to 3 months. And as soon as that appellate decision came out, all of the judges read it, and if you know anything about judges, they do not want to be overturned. It's an embarrassing mark in their record. It means they misjudged or misinterpreted the law. So as soon as that appellate court decision came out, all the judges shifted gears and started ruling against landlords if those notices don't have that language in there. It's never been required before, and the code didn't change at all. So that's the point I was making earlier when I said these little nuances can shift. If you're not deeply involved in this and you don't serve notices on an everyday basis, there will be some little nuance that you might miss. Just don't draft your own notices. It doesn't have to be my firm, whatever firm you use to handle your landlord-tenant matters. Just go to them so that you get all the proper language in your notices and it's served and done correctly. All right. Off that tangent now, we were talking about no-fault termination notices. They have to have the relocation assistance. The landlord gets to choose. Are you going to pay them directly, just like the Tenant Protection Act? Are you going to pay them directly, the relocation fees, or are you going to waive their last month's rent? I highly encourage you just waive the last month's rent. There's really no benefit to paying them directly. The minute you give them the notice, they're going to stop paying you rent anyway. If you pay them directly, they still may not pay you their last month's rent, and you'll be behind the curve on that. So just waive the last month's rent. And we talked about the specific language that had to be in that notice. For demolition and substantial remodel, same requirements. They have to have the notice of their relocation assistance and the amount of rent that's going to be waived. Plus, I told you before, you have to have the permits issued for the demolition work or all the permits issued for a remodel. Plus, you have to have a description of the scope of work. And again, you have to explain in the notice why it can't be done safely with the tenant in possession and why it can't be done within 30 days. All right, and the one aspect of Buena Park's Just Cause Ordinance that I really like is, unlike several other cities now, these notices, these termination notices, do not have to be filed with the city. Where I see a lot of cities starting to pop up with their own tenant protection ordinances, and they're saying, oh, you've got to file this notice with the city within 3 days of it being served on the tenant, and you've got to file it with the proof of service, etc. Whenever I see that, that tells me that that city is moving towards a rent registry, where they make you register all your units, and Buena Park doesn't have that. And so the fact that that requirement to upload it or mail it a copy to the city is a good sign. Let's talk about some miscellaneous notices that are required under the Buena Park Ordinance. They do require you to serve all your tenants with notices to tenants of California's rent control limits. Now, this is what's weird. What are we talking about? I just told you Buena Park doesn't have rent control. It's California's rent control limits. It's the TPA. It's the Tenant Protection Act. So you are, much like the Tenant Protection Act, you are required to serve the tenants in Buena Park with a notice of this. And again, it's got these strange dates. The tenancies created or renewed after July 1st, 2020. Well, you can use an addendum to do it. Like I said, an addendum has to be signed by both parties, so try to get it signed. Tenancies existing prior to July 1st, 2020, same thing. You're going to need an addendum. You need to add this to the lease. Why do I say you need to do this stuff? Because again, we talked about these administrative requirements. If you are not in compliance with the ordinance, a tenant can raise as an affirmative defense, well, you didn't comply with the ordinance. Unlike other ordinances that specifically say, in fact, LA County is trying to get this passed for their ordinance right now. Unlike other ordinances that specifically say, if you don't comply with this ordinance, the tenant can raise it as an affirmative defense in an eviction and your eviction will be void. Buena Parks doesn't say that, but it doesn't matter. It's still a good habit to be in compliance with everything so that you don't give the tenant or a judge who doesn't understand the nuances of this stuff. You don't give a judge an opportunity to say, oh, look, you didn't comply with the ordinance, so I have to dismiss this case. You can sit there and argue with the judge, Your Honor, that's not a part of the ordinance, and you still may find that the judge doesn't understand things, dismisses your case, and you have to start all over. So again, it just makes sense to comply with this stuff, even if it's duplicative and you have to comply with it for the Tenant Protection Act anyway. All right, and it's got this third provision as well that says tenancies created or renewed after August 1st, 2023. It's got to be part of the signed lease or the rental agreement, and you can do that again by an addendum. Now, here's something really interesting. This language in here has to be in 12-point font. All right, so if you're going to do it, you're going to put it in your lease, make sure it's in 12-point font. If you're going to do it in an addendum, there's no point in trying to bury it somewhere with 8-point font. Just put it in 12-point font. All right, the next notice that's a miscellaneous notice that has to be served is the notice of owner's reservation of right to terminate for owner occupancy. We talked about that, so I won't go into the detail. It's got those same 3 dates: before July 1st, 2020, after July 1st, 2020. The ordinance didn't even exist at that point, and then after August 1st of 2023. All right, let's talk about relocation benefits. So when you terminate the tenancy for one of the 4 no-fault tenancies, you have to pay relocation fees. They're mandatory. Again, what I like about Buena Park's ordinance is they're relatively low in comparison to a city, let's say Los Angeles, who you can end up paying a tenant as much as $22,500 on top of the fees to the city, on top of the relocation specialist you have to buy. Buena Park doesn't require any of that. And what it is if you're doing an owner occupancy, it's 1 month's rent. If you're doing an Ellis Act permanent removal, it's 1 month's rent. If you're doing a court or a government agency order to vacate, it's 1 month's rent, provided the tenant didn't cause the problem that requires you to vacate them. If they caused the problem, let's say they destroyed the inside of the unit and the government ordered you to get them out, you wouldn't have to pay them any relocation fees in that situation. The last one, the 4th category, is the demolition or the substantial remodel. That one is not 1 month's rent, and it's actually higher than the Tenant Protection Act. This one is the greater of 2 months' rent or $4,500. And so it's important to understand that, because remember I said if you terminate the tenancy, you have to put that notice, the language in there. How much rent am I waiving? And you might be tempted to put just 1 month's rent in there. Well, don't do that. Again, one of the little nuances. If it's a substantial remodel or demolition, it's got to be the greater of 2 months' rent or $4,500. So make sure it's spelled out in the notice. So that covers the relocation benefits. Really straightforward, really simple, and really simple ordinance in the bigger scheme of things. And then last but not least on the ordinance is, does a landlord have to register their units with the city? And the answer to that is no, as I said before. If you own property in Orange County, which you probably do, or you wouldn't be watching this webinar right now, you will know that Santa Ana, another city in Orange County, does have a rent registry. And it's convoluted, a little bit complicated, brings up a lot of privacy issues for landlords, compliance issues for landlords. Luckily, Buena Park did not build that in. So what's the takeaway in all of this? The takeaway right now is not so bad news. Yes, it is true. You do have a tenant protection ordinance that has recently been voted into place. As I said at the beginning of the webinar, the good news is that initially the City Council they intended to pass rent control. Instead, they looked at the situation, said we have rent control, we have the Tenant Protection Act, we're just going to strengthen the tenant protection ordinances a little bit, the just cause ordinance, and so they decided to decline rent control. They've got a very easy to follow just cause ordinance. It's what I would call a very basic vanilla ordinance. It's not onerous on the landlords. It does have some language requirements. It's not a model of clarity. It does have some issues, some convoluted provisions that I'm sure they'll clear up. All in all, they did a great job on drafting the ordinance, and it's pretty lightweight. What's the downside to this? As we say when we're in law school, it's a slippery slope. We learned that phrase in law school. Buena Park did pass a just cause ordinance. So now, what is to stop them, especially if they are getting barraged with tenant activist organizations at the City Hall meetings? What is to stop them from beefing this up even greater? What is to stop them from moving in a direction of Los Angeles? What is to stop them from implementing a more stringent rent control, from bringing that into effect? They've already said that they saw the need for rent stabilization. What's to stop them from doing that? And the short answer to that is you. You have to be the force that stops them from doing that. And the only way you're going to do that is to be there. You have to be at these city council meetings if you have residential rental properties in Buena Park. And this is true for every city. And I hate to say this, but I've been preaching this for the last 15 years that I've been a licensed attorney doing this stuff. I have seen some movement in this. I have seen more landlords getting involved over the since COVID, I guess, and that's great news. I have an alternative suggestion I'd like to make today. I still want everybody at these city council meetings. You have to be there. Know who your neighbors are that own buildings, rental units. Form a coalition, form a Facebook group, Buena Park Landlords Association, whatever you want to call it, or not association, but Facebook group. Get to know all these people, align with them, and instead of going to City Hall and just saying, hey, rent control is bad, or these just cause ordinances are bad, offer them an alternative. And I'll give you an example of an alternative it's not my idea, but it's been around forever, but I don't see any cities acting on it right now. One alternative is to say, instead of tenant protections, if you're really concerned about homelessness and you're really concerned about helping these tenants out, how about a landlord fund? How about a fund that the city takes up to help landlords out when a tenant falls behind in rent? Why doesn't the city, instead of, for example, the city and county of Los Angeles it hasn't quite passed, as far as I understand, it hasn't quite passed all the way yet, but they're looking at something called right to counsel. That is an extremely expensive proposition for taxpayers. Even if you don't own property, you're a taxpayer in a city or a county that's proposing that, your taxes are going to pay for all these attorneys that these cities want to hire to represent these tenants when they're in an eviction. And I could see, for example, Santa Ana taking the charge in Orange County and running to right to counsel. And when it's pitched to the city council, the way it's pitched is, it's a savings to the city because homelessness costs the city this much every year. And if you did right to counsel, it'd be on the taxpayer's back instead of the city's back, which they're one and the same if you think about it. But they show you how it reduces the cost. It doesn't reduce the cost at all. My point to this is, instead of running to right to counsel, why don't we, if you want to protect the tenants, create a landlord's fund? That tenant fell behind in rent. We're going to pay that to the landlord for the tenant, and the tenant can pay us, the city, back, reimburse the fund over the next 2 years, 3 years, whatever it happens to be. That is at least a viable alternative to rent control, to just cause eviction, to right to counsel, to all of these tenant protections that we see percolating right now throughout California. So we've taken up a decent amount of time on this. I imagine there's people who want to ask some questions. I've pretty much covered the whole ordinance. Like I said, all in all, compared to cities in LA, this is a cakewalk. It's not bad, but I do suggest as we say, it's the camel's nose under the tent. If the camel's nose gets under the tent, it's not long before that whole camel comes into that tent. So with that in mind, show up at your city council meetings, get involved in this situation, and keep this as narrow as you possibly can. And with that, I'm going to give this right back to Jeff.
Great. Thank you so much. That was, the devil's in the details.
Right.
The devil is totally in the details. And so just even those noticing requirements, that was really what I was hoping you'd talk about and just really lay everything out. So I hope that everyone watching today, I hope you got something out of it. If you're on AOAUSA.com, you can put a question in that little help, in that blue help button. Obviously, Facebook and YouTube, you know what to do. And big hooray for YouTube. We finally have closed captions live on YouTube. And before, it used to just be Facebook. So applause to YouTube for getting that taken care of. So we'll take some questions here. And I know people are writing some questions in right now. Just an email that we're going to be sending out here pretty soon is something about a live stream that we did 2 weeks ago, and that's that ACA 13. And this is something that I think they're going to vote on it on Thursday or so. And this is something you're going to want to call your representatives on. You'll see an email from us pretty soon. And then also, we had John Kupal from Howard Jarvis Taxpayers Association talk about it. It is not, ACA 13 is not the one that would repeal Costa-Hawkins. It's not that. I know people get that confused. This one is one that would make it easier for local municipalities to tax you. And so it's important to oppose it, especially as rental property owners. So anyway, that's something that's coming up. Hopefully we gave enough time here. On YouTube, we have Tom. We wrote to our tenants a 30-day change of terms to obtain renter's insurance and name owners as added insured. What do we do if a tenant fails to comply with this requirement?
That is a great question. And again, to complement this ordinance and the City Council of Buena Park, one thing that they left out, which I do see in other just cause ordinances, is, for example, the City of LA states that a landlord cannot unilaterally change the terms of the tenancy and then use that tenant's failure to comply as the basis for an eviction. Buena Park left that out. So you can change the terms of a tenancy on a 30-day notice as long as it's a month-to-month tenancy. And if the tenant fails to comply with it after it goes into effect, then you could terminate the tenancy. In this case, the one question that would the judge or the jury would have to answer is it a material term to the lease? Did the tenant violate a material term to the lease? And that's a little bit discretionary. Renter's insurance has not traditionally been demanded, although that's changing. That's especially in the last 5 years. A lot of landlords have gone to that, so it's changing industry-wide. So to answer the question directly, what do? You serve a 3-day cure covenant warning notice. Hey, we served you a 30-day change in terms of tenancy, requiring you to obtain renter's insurance and name us as additional insured. You failed to do it, and so you've got 3 days to produce evidence of that. If they don't do it in 3 days, you would then serve a 3-day quit.
Great. All right. And then Shirley, regarding eviction for non-renewal of lease, if the lease has language that says the lease will convert to month-to-month when it ends, can we still evict if the tenant refuses to sign a new lease?
Another good question, because that provision can be worded in at least 3 different ways that I'm aware of. And so it'll depend on the language of that specific provision. If it were to say it automatically converts to a month-to-month, then that's what happens. It automatically converts. But that doesn't mean that you can't require a tenant to renew on another fixed term. So I would say you are in safe waters by requiring them to renew for a similar term, another year. Now there's some alternative language that might say it will automatically convert upon the landlord accepting rent. And if that language exists, you could do something very similar. You would say, I'm not going to accept your rent until you renew or sign a new lease. And of course, you'd want to get all that new required language into that new lease. So just because it says it automatically converts to a month-to-month doesn't necessarily preclude you from demanding the tenant sign a new lease. I think you'd be fine doing that.
Great. All right. Well, do you have this is kind of a little bit off the subject, but like I haven't seen a whole lot on the Justice for Renters Act. We don't have a number on that proposition yet, do we? Do you know?
Not that I'm aware of.
Okay.
It doesn't mean it doesn't exist. It just not that I'm aware.
Right. Yeah. I haven't seen it yet either. So I was just kind of curious. Okay. Let's see. Roland, I'm a senior citizen and would like to retain Mr. Brennan regarding an owner occupancy no fault eviction. What is the best way to reach him?
Okay, so let me manage expectations immediately. Reaching Mike Brennan is not an easy task. But you can certainly reach the associate attorneys in my office. You can reach the staff members. That telephone number, the main office, is going to be area code 626-294-0500. Again, 626-294-0500. You can certainly ask. My staff is highly trained, and the associates are highly trained, and everybody's trained by me personally. In order to reach me, it would have to be an active eviction case or some active litigation that I'm involved in. Doesn't mean I won't answer your question. If I happen to be available when you call, I'll take the call. But my availability is often limited, so please call the office and talk to them. I think you'll find that they're very knowledgeable.
And you see also their info@mbrennanlaw.com. That would be the correct place to send an email.
Yep.
I like email personally. I know a lot of people like to hear someone on the other line, but at least to get things kind of kicked off and letting them give you a call back when they're ready.
I used to like email.
Yeah, I mean, right.
Now I can't control my email box, so I like phone calls.
Yeah, no, I same thing. It's the good and the bad of all of it. So, but definitely we appreciate it. And yes, sir. So you may have gotten this magazine. Here's the back cover of the AOA magazine, and we have 10 of the main speakers here listed, and I see Michael Brennan, Esquire, here. And he's going to be covering tenant protections and eviction requirement survival guide. That's the name of his talk. And that will be for what areas are you going to be covering at the trade show?
It will be general in nature, so I can cover quite a bit. When I narrow it down, it will most likely be in Los Angeles area. The trade show's in Long Beach, so it's going to draw a lot out of Los Angeles, and so I will. But I am also able to answer Orange County questions, and specifically, I may bring up an example from Buena Park or Santa Ana, any sort of new or evolving trend that indicate or is evolving in Orange County. I would address that as well.
Right, and then you will have a booth at the show.
Yes.
You'll be manning it, you'll
Yes.
have your staff manning it, and even when you're not speaking, people can come to your booth and
Oh yeah.
and kind of get to know you and ask questions and everything else, right?
Yeah, so for people who have called and either spoken with Cynthia in the office, she will often tell you if you're having trouble getting in touch with him. If you don't have an active case and it's just to ask a general question, you want to talk to me personally, the trade shows are great places to do it. I'm there all day. I'll talk to people. I'll answer questions. There's no time caps.
Yeah.
I'll take as long as it takes to answer as many questions as you present. So that's a great place to do it.
Yeah, Dan on YouTube, what are your thoughts on the rent control cases being presented to the Supreme Court?
I like them.
Yeah.
I like them. I like the question too, because I've said this over the last few years, and I didn't say it in this webinar. From what I hear and the feedback I get, this Supreme Court, and we've seen this already in several of their rulings, it's a very conservative Supreme Court. It wants to hear more private property rights cases. And so we've had some good results out of them so far. I think we stand the best chance we've stood when it comes to rent control than we have in decades. The question is, it takes forever, as they say in law, the wheels of justice grind slowly. And there's a lot that goes on prior to getting these cases to the Supreme Court. I know there are some teed up for it. I'm very hopeful. I think that the challenge will be that even the Supreme Court recognizes that cities do have, because housing is so important to society, cities do have the right to regulate it. And they do have the right to regulate it under their police powers. But I think hopefully what will be presented to the Supreme Court and what the Supreme Court will take into consideration is the abuses that ran rampant during COVID. So many cities across the country, including New York, California, Oregon, Washington, so many states and cities abused that police power during COVID, that I'm hoping the Supreme Court takes a look at this and reins it in a little bit and says, look, yes, you have the right to regulate private property under your police powers because it does involve a very important segment of society, but there are limits to that. A lot of what these rent control ordinances do amount to a taking. And you would think a taking is a very simple definition. It's not. There's different definitions for takings, and they can be very complex. And is it a financial taking? Is it a real taking? Is it just an administrative taking? So it's a very complex list of topics that will be heard by the Supreme Court. But like I said, I'm more hopeful about the outcomes right now than I have been in decades.
Great. Yeah, great question there. Looks like we have one more question from Chip. Okay, what are your thoughts on the lawsuit against Santa Ana's rent stabilization order?
I think that's funny because Chip and I were speaking about this a couple weeks ago. I think I know which Chip this is. Okay. Chip,
maybe it is.
I think that the city is setting itself up for problems. There are aspects of its rent stabilization ordinance that are problematic. It's got its own drama. The city of Santa Ana has drama going on with city council members right now. I think they are vulnerable, and I think this is the time for landlords to come together in Orange County as a whole, specifically in Santa Ana, get together and kind of run it over the finish line, right? This is your opportunity while the city is experiencing a lot of turmoil in the city council. So I think it's promising for Santa Ana as well.
Great. All right. Well, that is all we have for today. Again, Michael, thank you so much for sharing
You are
with
very
us.
welcome.
And I just love how you're detailed. You line everything out, and you dot your I's, you cross your T's,
Thank
and
you.
you help us just to avoid the pitfalls. So again, really appreciate it. We'll have one. We'd love to have you do one on Santa Ana rent control.
Sure.
And
We have talked about that.
so yeah, we had already talked about that. That'll be one that'll be
And
coming.
we've
down
got
the
one
pipe.
coming up for Inglewood also.
Yeah, we got Inglewood coming up, so we're just covering different cities.
Just
And,
so you know, we're doing this in office for the staff as well. We are
Uh-huh.
creating these bullet points on overviews of every city in Southern California that's got rent control. And I know there's more that have it on the table right now. We didn't even talk about that.
Right.
So, you know, whatever city that pops up with it, we're happy to address it in a webinar. And I also wanted to thank AOA. You gave me the opportunity to come here and kind of get out to a broader audience than I would otherwise with information that's important for the industry. So thank you.
And speaking of that, just share this with your friends that have property in Buena Park. Share it with them so that they can be in the know. And again, thank you so much for joining us. If you liked this presentation, give Michael a thumbs up on this thing.
Thank you.
He put a lot of work in. And we appreciate you again, and we'll see you next time.
Thank you.
There
All
we
right.
go.